Typically, people think of the NLRA as dealing with unionized employers and dealing with union organization drives. But the NLRA actually covers union and non-union employees, and it does so by ensuring that employees are protected from retaliation or discipline based on what is called in the Act protected activity. And that can be engaged in by both union and non-union employees. It's very interesting that we're talking about this topic because most employers, in fact most lawyers, again think that the NLRA really is governing unionization efforts and unionized employees. But as employees are disciplined for, say, defaming an employer on their home computer on Twitter or on LinkedIn or wherever they happen to be, Facebook, as discipline grows, people will become more aware that the NLRA does govern discipline given in these situations. So when you have all of the social networking, all kinds of law is going to come out of that. As employers assume that they can discipline employees for exposing, quote, confidential information, assume that they can discipline employees who put what the employer thinks is just confidential on their website, or they have been defamatory of a supervisor or of the company. All of these things are going to be examined now, and to the extent that somebody says, my boss is unfair and gets fired for it, then all of a sudden they will go to a lawyer that's going to look into that and see that indeed the NLRB has been ruling that there are protections for these non-union personnel. It's really going to be explosive. People have to pay attention even if they don't have unionized workforces to this, because almost all employers ought to have policies that protect their email system, policies that protect the use of their computers, maybe policies that protect confidential information. And so these are necessary policies to have. Well, now we have a federal agency that's really looking into seeing how this impacts employees' rights. And so employers should really take to heart changing to make explicit that they are not impacting employees' protected rights under the NLRA, and maybe specify that. Because to date, employers get away with saying, well, you can't use confidential information on your own Twitter accounts or on your own personal computers without specifying what an employer thinks is confidential. I think given the board cases, an employer should look at their policies and make them much more specific as to what they're trying to protect and what they are not trying to impact. And then they should weather the storm of expansive protections under the NLRA.